Please, Your Lordship, I beg to mention item number 7. Your Lordship, I pray that this matter be taken up after 2 weeks as the conducting counsel is unavailable.
It's no objection.
On prayer made by the appellant, seeking accommodation on grounds of personal difficulty by the learned counsel. Matter is adjourned. This is him after 2 weeks.
Daily list item number 1.
Please, Your Lordship. My Lord, I pray for a further 4 weeks' time to file my rejoinder to the affidavit filed by the all the respondents, my Lord.
Why 4 weeks?
My Lord, actually, we are awaiting for the outcome of the inquiry proceedings that has been concluded and a report has been submitted to the EC. In view of that fact, I pray 4 weeks' time may be granted, my Lord, in case anything's come up.
Mr. Learned Counsel for the petitioner has sought for further 4 weeks' time to file the rejoinder on the ground that the outcome of the decision of the executive committee in a related matter is still awaited, which decision will have a bearing on the merits of this case. The prayer not being objected to by the respondents, that is adjourned. This is after 4 weeks.
Highly obliged, Your Lordship.
Item number 2.
Lordship, this is the continuation of delay, Lordship.
Parties are present.
Lordship.
There's a private party here. This is connected to item number 4.
The appellant.
Lordship, she is appearing through video conferencing. Lordship.
Yes, miss.
She is not audible.
Unmute yourself.
Your Lordship, in item number 4, I'm for the appellant, Your Lordship.
Item number 2.
Private respondent, I suppose, here.
No, in item number 2, you've received notice.
No, Your Lordship, not yet.
Lordship, today is the first day of listing, Lordship. We will be, through WhatsApp, we will be sending them notice, Lordship. Lordship, this is the continuation of delay. Today only.
You have to comply with Order 41, Rule 22.
Lordship.
So I will receive notice for 1 and 2, my Lord. At page number 1 and page number 2.
So you have to take you're not accepting notice on behalf of respondent.
I'll accept the notice, Your Lordship. They can serve us a copy.
Through WhatsApp, we will serve, Lordship.
Your Lordship, or we can ask
who is your local colleague here?
Local counsel is not present today, Your Lordship. In the meantime, during the course of the day,
who is he? Who had appeared on behalf of this one?
Mr. Imol, Your Lordship, he is not available today.
Has he executed the power?
No, Your Lordship. In the meantime, we'll file wakalatnama also in this particular case, Your Lordship.
Okay, you make that arrangement.
Lordship, through WhatsApp, we will.
Whatever the case may be, if it is acceptable.
Lordship.
Yes, Your Lordship.
Ms. P. Bhattacharjee, Leonard Counsel for the applicant, has submitted that an appeal has been preferred by the applicant against the judgment and order dated 11/3/2020 passed by the Leonard Special Judicial Officer. This is Shillong,
No, Nongpo.
Riboy District, Nongpo, Riboy District. In what's the case number?
In LA case number 10109
In LA case number 109
of 2015.
of 2015. Next, however, a delay of about 925 days has occurred while preferring the said appeal, for which this application has been filed seeking condonation of such delay. Next, the Learned Counsel has further submitted that notice may be allowed to be issued upon the respondents. Mr. SN, Leonard G has accepted notice on behalf of respondents number 1 and 2. As such, no formal notice is required to be issued. Copies of this application and the proposed appeal, memo of appeal, may be furnished to the said, to the Leonard G. Miss, your name is?
S. Niwar, Your Lordship.
Ms. S. Niwar has also submitted that she is accepting notice on behalf of the respondents number 3 and 4, and on receipt of the copies of the application and the related memo of appeal, the power will be filed accordingly. Next, the Learned Counsel for the applicant is directed to also furnish copies upon the said respondent, furnish copies of the said application and memo of appeal on the Learned Counsel for the said respondent number 3 and 4. Next, the respondents are at liberty to file a response to this application. The same to be filed within the next date fix. This is matter for further orders. This is matter for hearing on this application on the next date fix. How
Your
long?
Lordship's convenience. Sorry, Your
Only
Lordship. Subject to Your Lordship's convenience, on 31st of July, Your Lordship, the matter can be fixed.
31st July. Now,
31st of July.
why so long?
Your Lordship, there is difficulty on the senior counsel's part.
Oh,
So,
application.
yes, Your Lordship.
So 31st, Mr.
Lordship.
Lordship.
As agreed to by the parties, list this matter on 31st July.
Obliged, Your Lordship.
Item number 4 is a connected matter. That may also be listed on the 31st minute.
So, phone issue thought, as agreed to by the parties, list this matter on 31st.
Lordship. Highly obliged.
Obliged, Your Lordship.
Thank you.
Item number 3,
May, may I please your lordship? My lord, here in this case, I like to raise a very important question of law, my lord. The question is whether, my lord, the merit list of a scheduled tribe and scheduled caste, can it be merged together? Whether constitutionally is it allowed? So this is a question, my lord. In my humble submissions, my lord, it can never be allowed, my lord. Why? Because scheduled tribe in itself is a different class, and scheduled tribe itself is a different class. Both are separately recognized under the Constitution of India, Article 351, 350. Article 354 for the scheduled caste and Article 342 for the scheduled tribe, my lord. So, having said that, my lord, now I like to take, my lord, to the facts of this case, my lord.
So there's a separate list drawn out.
Yes, no, both the leases were merged together, my lord.
No, I mean,
It has to be drawn.
See,
Yes.
constitutionally,
Yes.
separate list has to be.
It has to, yes, my lord. It has to be drawn. Now, my lord, we recall the reservation policy, of the state of Meghalaya.
Yes.
40% for Khasi Jaintia, 40% for the Garos, and 10% for the general, and 5% for other backward classes, my lord. Now the issue is, but I like to just clear myself that I'm not touching the reservation policy, my lord. I'm only questioning the act of clubbing in these 5% the different categories together, drawing the merit list together. I'm only questioning that they could have done it separately, my lord, in there also, my lord. Within 5% also they could have done it together.
You mean within that 5%?
Yes.
There should have been some, separate bifurcation.
Yes, there should have been separate bifurcations, my lord.
You know,
Suppose there are two, say for example, 2 posts left for the other backward classes. Now, one post separate list, scheduled caste should have been separate. One post, the best of the scheduled caste will get the one post, and the best of the scheduled tribe will get the other post. Now you cannot club together. Now if you club together, in this case what happened is they have all clubbed together, they have merged together. Now what happened is in the merit list, only the scheduled caste 2 posts, for example, 2 posts are taken by the scheduled caste and the scheduled tribes. The other scheduled tribes did not get any. Did not get. So this is the act of this that I'm questioning here, my lord. So which is not permissible in law, my lord. So I'll just take to just brief facts of this case, my lord. So my name is Jobaraj Boro, and the page 21 is my caste certificate, my lord.
what are the background facts?
Yes, my lord. So the background of the case facts is that by Annexure 3, page 24, there was an advertisement, my lord. The advertisement was issued by the Director General of Prisons, Meghalaya. My lord has got page 24.
Yes.
Yes. By this advertisement, my lord, the Office of the Director General of Prisons have issued an advertisement for recruitment to various posts, my lord. And what we are concerned here,
Advertisement dated?
this is advertisement dated is 21st of May 2015, my lord. So by this advertisement, my lord, various posts were asked to be filled up, my lord. And what we are concerned here is serial number 2, that is warder's mail, my lord. So there are 60 number of vacant posts, my lord. So there was an advertisement being qualified, my lord. Yes. I applied for the post, and after all the recruitment process, my lord, I was selected, my lord, and by page 30, that is the order, my lord. By page 30, this is the order. my lord, may I just read? In pursuance of the prison's recruitment advertisement dated so and so, 21st May 2015, and in the interest of public service, Shri Jobaraj Boro hereby appointed to the post of mail warder, duly supported by police verification by so and so, medical fitness certificate received, so the plus allowances as admissible from time to time with effect from the date of the joining. The period of probation shall be 1 year from the date of joining. So, pursuant to subsequent to this order, my lord, by page 37, I have submitted my joining report on 2nd of March 2016.
Page 37.
By page 37, my lord, annexure 5. I think that's wrong.
Yes. Page 37 is
31. Sorry, it's 31. It looks like 37. Annexure 5. Annexure 5.
yes.
Page 31, annexure 5. So by this, my lord, I have submitted my joining report.
Yes.
By this, I have joined and I started working as the mail warder, my lord. Then comes, my lord, some of the unsuccessful candidates, my lord, have challenged, and by annexure 6, page 32, my lord, the recruitment, the appointment orders were stayed, my lord. Page 33, may I just read the last portion, my lord?
Page
33. Page 33.
Yes.
On perusal of the order, the last paragraph I'm reading,
Yes, yes.
it is clear, it is very clear that when the stay operation was moved, the government council never apprised the court that the appointment letters had already been issued to some of the candidates whose names appeared on the select list. Secondly, this court also had given an opportunity to the respondents to move an application for alteration or modification of the instant order. However, none has moved any application for alteration or modification, nor informed this court about the said appointments, for which I express my anguish and displeasure. And it's a clear case of violation of the court's order, which amounts to contempt of court. Since the wrong has been committed by them and it cannot continue, the respondents are directed to temporarily suspend the appointment of those who have been appointed till the outcome of this petition. So by this, all the select lists were suspended, my lord. Now, my lord, and pursuant to this, my lord, by page 34, my lord, the next page, the Inspector General of Prisons passed this order, my lord, page 34, annexure 7.
Yes.
And this is a compliance of the order of the court, my lord. He says, in pursuance of the order dated 17/4/2017 of the Honorable High Court of Meghalaya, the appointment orders issued earlier by advertisement dated 21st May 2015 are hereby suspended temporarily until further orders, my lord. So, finally, my lord, the single bench has taken the case and a wide order dated, my lord, wide order dated 19th July 2017, that is page 44, dispose of the matter. By page 44, dispose of the matter, my lord.
Yes.
Now my suspension, because of there was no relief to the select list, my lord. Therefore, finally, my lord, then the state has taken this order of the single judge, my lord, has assailed by filing, my lord, a writ appeal, and the writ appeal order is at page annexure 9, page 75, my lord.
So this order is was in your favor.
Yes, my lord. Yes. So on 22nd 09/2017, when the division bench took up this matter, my lord, assailing the order of the single judge, page 83, the last paragraph, my lord, can you look? Page 83, the last paragraph, my lord. May I just read, my lord? For what has been observed and discussed herein above, we find that a prima facie case for grant of interim relief is made out. The balance of convenience is also in favor of the appellants, and obviously, if the entire process is put at hold and no appointments are made or allowed to be made, it would only prejudice and adversely affect the administration. Even while making these observations, we need to put a note of caution that for the purpose of making appointments, it is necessary that the select lists are re-examined and appropriate final select lists are issued. It has been indicated during the course of submissions that as regard the respondents, Rajan Balmiki and Bhakta Prahlad Das, writ petitioners, appointment orders were issued after finding that they were standing in the merit list of SC category and were entitled to be appointed on the merit. After taking note of the aforesaid facts and without any other comment, at present we are of the view that the operation of the effect of the order impugned be stayed, but while providing as under. It would be expected of the state government to review its reservation policy in accordance with law while keeping in view of the principles in M. Nagaraj and others versus Union of India, Ashok Kumar Thakur's case, and also S. V. Joshi and others' case. For the purpose of carrying out this process, the pendency of this appeal shall not be of any impediment. It shall be open for the state to allow rejoining of the candidates selected in the selection process in caution, while making it clear to each of the appointee that his or her appointment or joining shall remain subject to the final decision of these appeals, and joining by itself will not confer any additional rights. So therefore, my lord, now consequence upon
Yes.
So consequence upon this, my lord, upon this order, page 13, page 85, the next page, my lord, we were allowed for 2 months, my lord, we were allowed to join temporarily for 2 months. The following mentioned names are hereby allowed to officiate temporarily in the office of the superintendent of jail, so long as a warder for 2 months. So plus, this is Jobaraj and Ranudir, my lord, who are before my lord. So they were allowed to join for 2 months, my lord.
This is not the final order. Is this the final order?
No, this is not the my lord, the final order.
You see, the appeals are posted for hearing in the month of October.
Yes, the final order is page 87, my lord.
Okay.
Page 87, Annexure 12 is the final order, my lord. It's a small order, may I just read, my lord? It is fairly submitted by the appellants and the individual respondents that a common judgment impugned dated July 19, 2017.
But I'm party to this order.
My lord, my lord, in the writ petition, we were party, my lord. We have made a party.
This order was passed by CJ and myself.
Yes, my lord.
Does it have any?
In this, my lord, I'll have to see because the writ appeal, my lord, in the writ appeal, we were not a conducting counsel, so and
Lordship, kindly come to page 87, Your Lordship.
Yes, CJ.
Lordship, Lordship was part of that bench.
Exactly. That's what I was pointing out.
yes. Oh yes. Yes, I was okay.
If it has touched on the merits of your case, then I don't know.
My lord, then let us adjourn for 1 week, my lord. I'll just take proper instructions. Because here, after my lord's order, there was a redrawing of the select list. Now the redrawing of the select list was done in such a way, my lord. SC, ST, which I was coming back now to the low points, my lord. They have been clubbed. They have merged together. So therefore, the two petitioners which I've mentioned, Prasad and those ST candidates, SC candidates, they supersede, they were appointed in our places. And there is another point also, my lord. When an SC candidate or an ST candidate secures more mark in merit than the cutoff of the general category, then he should be included in the general.
Should be included in the UR.
Yes, unreserved, yes. So if it's like that, then these two gentlemen gets to the UR, then the
SC category becomes vacant.
yes, it can become vacant. So therefore, it's not touched. Yes. So therefore, it is this. Even if my lords allow, it is not going to touch anybody's post because the UR will go up.
But what about we can see in UR? By now, that UR slot is already filled up.
Yes.
Then somebody has to push out from there.
Petitioner cannot blow hot and cool, your lordship. He appears as a Shell tribe candidate, your lordship.
No. That's I think we completely misread me. What I was saying is, even if I appear as a scheduled tribe candidate, in case I secure more marks, that's a law, more marks than the cutoff of the general, I should be accommodated in the UR.
Yes, that is settled.
That is there. So therefore, what happened is that the scheduled tribe.
You apply as a Shell tribe.
No. I am not claiming under the.
That is beside the point.
Yes, that's besides the point. So, my lord, kindly give me 1 week. I'll just confirm with this.
You see, because I've not read this order.
Yes.
You just read and just Mr. Shulai.
Lordship.
You read this order.
Yes.
See what is the purport of this order.
Yes.
Whether it will affect my capacity as a single.
Lordship, because it was on the basis of that order, your lordship, that the list has been withdrawn, your lordship.
So
and finally, your lordship, when the hearing, when the writ appeal hearing took place, your lordship, everybody agreed. Yes, that single bench, the order of the land single is required to be set aside, which was done.
No, that is a different thing. That we are not going.
Yes.
Only on this point, where my name appears.
Yes, correct, my lord. Well, I'll take.
Whether it's propriety,
Yes.
That I should appear or not.
Yes, my lord.
I should take up the matter or not.
Correct, my lord. Because what they have wrongly interpreted is my lord's orders, because no judicial order can override the constitutional provisions. No judicial order. So now they have misinterpreted that the order of my lord.
But why you have not, proceeded further? You could have gone to the Supreme Court.
Should have filed
my lord.
SLP.
If that has really affected your merits or your case.
Yes, correct, my lord.
You could have gone. Then that will be clarified as far as the law.
No, but why? Because that part of what my lords have directed with his lordship chief justice, we are not aggrieved with that one. Now we are aggrieved with the manner in which they have drawn by merging together. My lord's orders were very clear. You redraw it. Redraw it means what? If you redraw it like these two gentlemen, they are as an SC category. If their cutoff marks are the below cutoff marks, they score more than the below cutoff marks of then you accommodate. So in that way you draw the list. This is what I understood. But here,
like I said again, you see that will upset the UR list.
UR list, my lord. Then I'll have to make them.
Now we have to make them a party.
Party, my lord. So my lord, kindly give me 1 week time, my lord. I will just try to clear all the. I am so sorry, my lord. I did not see my lord's name.
I thought I am very popular, but
my lord is indeed.
So 1 week then?
1 week, my lord.
Lordship.
1 week.
Should we fix it on 16?
16, my lord. Yes.
16. Yes, lordship.
You try to get instructions. See
Lordship, yes.
what is probably on pre-made by the parties. This is matter on 16.
My lord.
Oblige, lordship.
Same order.
Same order.
In the next item, same order will follow.